Hello, good afternoon. It's Deb's True Crime Notebook, back with more documents to read for you so you don't have to. Believe it or not, the defense has filed another motion, and this time it's Jennifer Auger, the female of the trio for the defense, that's filed a motion to reconsider the motion to correct errors. Let's see what Jennifer has to say. State of Indiana versus Richard M. Allen. Defendant's motion to reconsider denial of motion to correct errors. Comes now the defendant, Richard Allen, by counsel and files his motion to reconsider denial of motion to correct errors for the reasons that follow. In light of Glossip versus Oklahoma, case number 24-7466-2025 WL 594736. As revised February 25, 2025, Mr. Allen requests the court reconsider its denial of the motion and either vacate Allen's convictions or set the motion for a hearing. At trial, the state argued that Brad Weber came home from work in his Ford Econoline van on February 13, 2017 at approximately 2:30. The state also argued that Liberty German's cell phone did not move after 2:32 p.m. on February 13, 2017. The state further introduced a confession written by Dr. Monica Walla that Richard Allen told her that on February 13, 2017, he kidnapped Abigail Williams and Liberty German on the south side of the Monon High Bridge and was on the south side of Deer Creek with the girls intending on raping them when he saw a van and became scared. Richard Allen allegedly told Dr. Walla that after he saw the van, he forced Abigail Williams and Liberty German to cross Deer Creek to the north side, where he ultimately killed them. As set out in his motion, the state knew or should have known that Brad Weber's trial testimony that he returned home in his van at 2:30 p.m. on February 13, 2017, before Liberty Germans permanently stopped moving at 2:32 p.m. was false. See motion to correct errors at 8:13 and attached exhibits 3A, 3B, 3C, 3D, and 3E. In fact, Mr. Weber arrived on his property drive at 2:44 p.m., well after Liberty German's phone stopped moving on the north side of Deer Creek at 2:32 p.m. See motion to correct errors, Exhibit 3A, additionally, Exhibit 3E to the motion to correct errors. An FBI subject information sheet from Mr. Weber shows that Mr. Weber's cell phone first started pinging at his family's house at 2:50 p.m. that day, also well after Liberty German's phone stopped moving at 2:32 p.m. The pinging of Brad Weber's phone is consistent with his arrival after 2:42 p.m. and not consistent with an arrival time of 2:30 p.m. In light of the security video and the FBI subject information sheet from Brad Weber, the state's narrative that Mr. Weber's interrupted Mr. Allen before 2:32 p.m. is impossible, and the state knew it. In Glossip versus Oklahoma, decided last month, the United States Supreme Court said, the OCC, Oklahoma Court of Criminal Appeals, also held that Sneed's testimony was not clearly false because Sneed was more than likely in denial of his mental health disorders. 529P, 3D, 218, 226, 227. It is not apparent why the OCCA thought Sneed was in denial, nor why such denial should have caused Sneed to believe that he had never seen a psychiatrist, when in fact he had. Even supposing it did, however, Sneed's beliefs are beside the point. What matters is that his testimony was false and a prosecutor knowingly let it stand nonetheless. NAPU 360 U.S. 264, 269, 1953. It is established that a conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. Glossip versus Oklahoma, number 22-7466, 2025 WL 594736, the Supreme Court, 2025. Regardless of whether Mr. Weber thought he arrived home at about 2:30 p.m., the state knew or should have known Mr. Weber's testimony was false and knowingly let it stand. The state's refusal to correct Mr. Weber's testimony and letting his false testimony stand violated Mr. Allen's due process right to a fair trial, as stated in NAPU and argued by Mr. Allen in his motion to correct errors. See motion to correct errors at 8. Because the state explicitly relied on Mr. Weber's false testimony to obtain Mr. Allen's convictions, Mr. Allen is entitled to a new trial. A. New trial is warranted as long as the false testimony may have had an effect on the outcome of the trial. NAPU 360 U.S. Act 272. That is, if it, in any reasonable likelihood, could have affected the judgment of the jury. Giglia versus United States 405 U.S. 150 154 1972, quoting NAPU 360 U.S. at 271. And the footnote at the bottom. The full 82 pages of the Supreme Court's opinions in Glossop are available at this link in the Supreme Court web page, and you will find the link at the bottom of this page. Glossop slip OP at 17. In light of Glossop's unambiguous reaffirmation of NAPU, the court should reconsider its denial of Mr. Allen's motion and either vacate his conviction or set Mr. Allen's motion for hearing. In conclusion, for the foregoing reasons, Mr. Allen respectfully requests that the court reconsider its denial of the verified motion to correct errors and either vacate Mr. Allen's convictions or set that motion for a hearing and for all other relief just and proper in the premises. Respectfully submitted, Jennifer Auger. So, let's recap this. It's short and sweet. I'm appreciative of that. It's not like Mr. Baldwin's multiple pages saying every description and every little bit of information. Jennifer Auger gets down to business here, says what she has to say, and gets out, and I really appreciate that. It's a little bit confusing here and there, a little choppy, but other than that, I'm grateful that she did it in a concise manner. Nothing big here, folks. It's what they've asked for several times. They're saying that Brad Weber was incorrect about the time that he got home, and that Abby or Libby's phone stopped moving at 2:32. He did not get home at 2:30. They think he got home at 2:44 in his driveway because they did have something on camera as they passed by another house. It was a security type camera. However, that security camera, if you recall, was off. It was saying AM when it was actually PM. And so therefore, we cannot verify that the actual time of the clock built into that camera was correct either. They say it coincides with when he walked in the house and Wi-Fi picked up his phone. And that could be that he walked in, obviously, at 2:50. That doesn't mean that he didn't get home and piddle around in the yard or the barn or garage or whatever and not enter the residence until 2:50. So either way, we'll see what Judge Gull has to say about this. I'm just trying to show you both sides. I've read about their side, and then I've given you a recap explaining what could have happened on the other side. It's good to look at both sides. We'll see you next time on Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications. Please share this channel with your friends and share this video with your friends and in your groups. And leave us a comment. We'll see you next time. I'm thinking we might be getting a response from Nicholas McClelland soon. We'll let you know when we do. Have a great evening.